Hello, 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 hello. Thank you for joining us for another episode in the Local Governance and Development series here on the Serenity Resource Connector, brought to you in partnership with the Clarendon Municipal Corporation and our program partners, Serenity Consulting Services, Sha-Gore Aggregates Limited, Cousins Construction Services Limited, and National Self-Serve Wholesale. I am Winsome Sharia Whittle, the founder of Serenity Consulting Services, host and producer for the Serenity Resource Connector. If this is your first time here, let me extend a warm welcome to this space. This is a space for public education as we have weekly conversations on Thursdays, 8 p.m. Central Standard Time with different entities each week as we learn about the different aspects of what it is that we need to do and how we can go about doing so. So this series, we're focusing on the activities at the Clarendon Municipal Corporation. However, the same activities that are in Clarendon is the same in St. Catherine and all the other municipal corporations across the length and breadth of Jamaica. So the information can be utilized whether you are tuning in from Clarendon, Manchester, St. Catherine, wherever. So thank you so much for being here with us. And on this episode, we're going to be focusing on planning on development. And to get that discussion going, I'm going to invite on our guest for this episode in the person of Nickala Thompson, Director of Planning at the Clarendon Municipal Corporation. Welcome to the Serenity Resource Connector space, Lady Thompson.
Good night, Mrs. Witter. How are you?
I am doing great, and I trust you are also.
Well, I'm trying to be.
You are being. It's showing. All right. Thank you, Sissy. It's my sister joining us all the way from the States. All right. Thank you all for tuning in. And as we do each week, feel free to share your comments, your questions in the chat, and we will seek to respond to it live. But I'm going to go ahead and kickstart the discussion.
Okay.
Lady Thompson, going to start by sharing a little about what really your portfolio, what are the key services that your department, the planning and development department, what are the key services that's offered by your department?
Okay. Good evening to everyone. Welcome to this program. And I do hope that you do enjoy the information. It is timely for you and you would utilize it in some way, shape, or form. The Planning and Development Department is one department of the Clarendon Municipal Corporation, similar to other municipal corporations right across the island. We are in charge of all things development, and development has such a large myriad of things that when you think of it, everything that you have to do when it comes to land itself is a form of development. We offer many services in the department, namely issuing of building permit, subdivision approval of advertisement, and recommendation through modification of covenant, just to name a few.
All right. And we are going to get into the details of those. So we're going to start by taking a deep dive into building permit and a little bit of subdivision, but more so building permit.
Okay.
Why do I need to apply for a building permit?
And that's a good question. That's a good question. Mrs. Witter, undertaking any form of building works is an investment. And, with investments, it has to be protected. So therefore, your building permit is your protection. Now, the permit is a legal document under the Building Act, of which any person wishing to undertake any form of building works, whether you're constructing, adding onto the building, doing any change of roof, doing any structural repairs, that has to get a an issuance of an building permit. Now, the building permit is issued under the premise that you have submitted a building application to the corporation, and that goes through the necessary processes, of course, sending in the various documentations with that. And at the end of the process, a decision is made by the corporation at a committee meeting, which is Planning, Environment, and Development. And it's either you're offered an approval or refusal. Now, the permit is issued with conditions at the point where it is your building application has gone through the necessary review, and it has found that it has met all the safety and public health standards, and it has met all the building codes and the zoning codes. Therefore, you may say to yourself that at what point really should I be getting this permit? It should happen before you do construction, not during, not after, but before you do construction. Have that document in hand and you safeguard yourself, protect your investment.
Indeed. And I would imagine that part of that, because we're in the hurricane season, and in the event that the steps were not followed and all of that should happen, you're going to have problem getting insurance coverage.
Correct. That is one of the main benefits, ensuring that you will protect that investment. Because during the construction phase of your application, inspections are carried out right from the ground foundation right up to the roof. So once it is that you have met all your standards, you are clear with your inspection, safeguard yourself even through the adversities of a hurricane, storm, whatever it is. So it adds to that level of protection that you get, knowing that you went through the process, you got approval, you have your building permit in hand, and it safeguards everything.
Indeed. All right. But how long does the permit last? Because it can't be valid forever.
No, not at all. All right, so your building permit lasts for 6 months. At the end of that expiration of the 6 months, you may revalidate your permit. And the process of revalidation would entail you taking into the corporation that package that you have gotten with your building permit, which would include your sets of building plan, your cover letter, your conditions, and of course your building permit. It is very advisable that you try your utmost best. Don't come to the office when it has expired. Come a little few days before, even a month before, to try and catch the next available meeting. As we have only one meeting per month, which is the first Thursday of each month. So it is always advisable. Don't allow it to expire and say, all right, fine, I'll get another 6 months. In fact, the date that is on your building permit, the date of expiration, the next one would start counting as close to that as possible to ensure that you get another 6 months. So if in the event that you did not get to break ground, and when I say break ground, ensure that your foundation is excavated, you lay your steels and get your inspection. You can cease construction and still that permit still has a full life. It's indefinite, right? Now, in the event that you did not get to break the ground within that 6 months and you are revalidated, you have up to 2 years to continue your revalidation process. However, if a day after that 2 years has passed, you are considered the process of resubmission. That unfortunately, you have to start the process all over again as if it was a new application, which indeed at this point it becomes a new application. You start the process all over again, pay the new fresh fee, submit all your documentation. So you resubmit at the end of 2 years, but revalidation for every 6 months up to 2 years.
Okay. All right. So let's talk about the documents, that initial stage. What are the documents that you need to present?
All right. Very good question. In terms of the documentations are quite similar right across the board, except the number of plans to take in. So I'm going to be speaking of residential and commercial just to give you a little difference. Now, first and foremost, you have to fill out and complete an application form. You will be visiting the Roads and Works Department. They're located on Brooks Avenue, on the same road as the fire department. And of course, if anybody comes into Maypen, knows National Wholesale. So it's on the same road precisely. Now you complete that application form at the Roads and Works Department. Along with that application form for residential applications, you'll be taken in 4 detailed copies. Building plans must be drawn either by an architect or a draftsman. Preferably you have a professional building practitioner, right? So we're out with the number of plans for residential. For commercial, we take in a minimum of 10. Depending on the nature of it, we may indicate to you that if it needs an environmental permit, which has to be done straight at NEPA, then you'd have to add some additional copies. But just to process at the local level, and if it needs to be sent to any other agencies, we take 10. Now, here's the similarity documents. Now, additionally, obviously, you have to take in either your surveyor's report or your surveyor's diagram. And we need either of those documents. And the reason we say either is because with regards to the report, you can get that maybe in a 2 weeks period from a reputable commissioned land surveyor. And this must be a commissioned land surveyor. Now, the report is what we consider a sketch diagram. It's not as precise as the surveyor's diagram, but we utilize same because the surveyor would have to go out, utilize its instruments to prepare the document. Now, in terms of a diagram, that has to go through another entity, national land agency, whom will be going through the process to get it registered, etc. And that usually takes a longer period, maybe up to 3 to 6 months thereabout, you can get your diagram. So because of the urgency of the need for the survey's report, we say taking that instead of the diagram. Along with that, you're going to need your certificate of payment of taxes, and that is for your property tax. When you pay your property tax, it's not the receipt that we need. In fact, we need a certificate. That certificate indicates that up to that point, you are not in arrears of any property tax up to that point. You can either pay it off for a year, half year, or quarter, depending on the nature of it. But we always recommend, because you don't have to go back to the tax office, at least pay it up to a year. When you're conducting business with the government, TRN and your ID are essential. We want to know whom we're dealing with, don't it? Right. Additional to that, your proof of ownership. How could we forget that? Your proof of ownership. We want to know that whomever is making the application for building permit is indeed the owner or the beneficiary, as in some cases. We have a number of different types of proof of ownership that we take in for a development application, and namely, if you're working with any other government entities such as NHT, HAJ, and that's Housing Agency of Jamaica, National Housing Trust, or even the National Land Agency, based on Commission of Lands Properties, you can get a letter of possession from them, right? Other than that, obviously, the registered title is a must. If there's a registered title for the property, we need to see it because the endorsed name must be the owner. In addition to that, you have other forms which some persons may come with their sales agreement, but we always encourage, once the property is indeed registered, add to that your registered title too. Unfortunately, there are many properties in Upper Clarendon that are unregistered. For whatever reason, those owners did not get the opportunity to get their property registered, hence getting their titles. So from time to time, based on discussion and getting information from the client, we do take on declarations. And this must be declaration from an aid citizen in the community that knows of the transaction between X and Y. In addition to that, a JP, Justice of the Peace, from the area, who also knows of the transaction, must send in a declaration. So that's 2 declarations that is needed. Other than that, for the documentation, you have to pay a processing fee, definitely, because it's a service that you are rendering from the Clarendon Municipal Corporation, and that service comes a price. It depends on the type of application that you're making, then it has a calculation difference. We utilize a percentage, which is forms the regulation of the Building Act. And for different types of application, there's a different stated percentage at this time. Other than that, you just come in with your application, it goes through the review process, you take it, it is submitted and registered.
All right. Very detailed. All right. If you missed any of that, just in case you weren't taking notes, the recording will be right there on the Serenity Resource Connector YouTube channel. So you can go back and make note of what it is that you need to submit. And it's a long list of things with all that's happening now. Can these be submitted online, or do we have to come in office?
All right. Well, currently by law, we only accept in-office submissions. However, due to technology innovations, our government currently is undertaking an pilot project in 3 parishes, St. Anne, St. James, and Kingston and St. Andrew, to through the Jamaica Development Applications Portal. They are utilizing that to take in online, but it's just in the pilot stage. Eventually, I'm of the opinion that during the review and the completion of those 2 pilot projects, 3 pilot projects, then the other parishes will get the chance to get on board. Now, through that online portal, persons will be able to submit both building and subdivision application. And there's also a payment portal on that. So instead of coming in, going to the cashier, you simply press your buttons on your computer, the money is paid, application is considered submitted.
Sounds good. All right. I love the movements.
Yes.
All right. So the next thing then is does the application have to be submitted at the municipal corporation in the parish where the construction will be taking place?
Well, I tell you now.
In each parish?
I tell you, yes. The building permit has a geographic jurisdiction. If you're making an application, if the property is in Clarendon and you made the application in Clarendon, not St. Anne, not Portland, not Westmoreland, your permit has a geographical jurisdiction. So whatever it is, any property in the parish that for any development of land on that said property has to be done in the respective parish only. And unfortunately, your building permit is not transferable. So it's not as if you can get the approval in Clarendon and don't decide to build in Clarendon and take it to St. James, for instance. It's not transferable.
Oh, all right. All right. Because when those fees are collected, I believe it would be very difficult to let go of those to send it to another municipal corporation, right?
I tell you. Yes, definitely.
Right.
Yes.
So how can those fees be accessed? Is there anywhere that the current fees can be accessed without coming to the office?
We currently have a website of which we try our utmost best to get it updated as often as possible. Other than that, you can call in at our numbers 986 2217, or you can email the department at clarendonpcplanning@hotmail.com.
All right. So we're going to ensure that all those information is shared in the link.
Yes.
Right at the end of the video. All right. So Zed's Financial Group Limited is saying that as a new home builder, this is informative. Okay. Fantastic. Awesome. Romeo knows for sure this will be a very interesting program. It's already shaping up to be, Romeo, and we're not even halfway there yet.
I like that.
Yes. Ava, welcome. Ava, phenomenal women of Clarendon. Yes, we are. accepting it. Thank you so much for tuning in, and just stay tuned as we continue the discussion. There's much more that we're getting into. Right. So this whole matter of, all right, so we've submitted the application,
Yes.
and something is not right, so it's not approved when it goes to that meeting on first Thursday, you said it is?
Yes, it is, of each month.
Right.
Except in
Right.
August, we're on recess.
Okay. Right. So can the application, the decision be appealed?
Oh, definitely. It is with regret to inform that there are times when the building application does not meet all the necessary standards, and we have to go make a decision of refusal. However, that refusal entails that we have to write the client, giving them specific reasons why the application was refused. In that same letter, we have to indicate to them, and by law, they can receive a refund of up to 50% from for the amount that they paid for the application. In addition to that, depending of the nature of the breach, it could either be matters pertaining only to the Building Act, which in that case, it goes to the Building Tribunal that is housed at the Ministry of Local Government and Rural Development. Or if it has planning ordinances that it has been refused based off that, there's an appeal to the Minister in charge of land under the Town and Country Planning Act. So it's dependent on the nature of the breach that either entities actually have an hearing with the minister, has an hearing, and makes a decision and informs the corporation and the client of that decision. There are times when the minister may have the decision of the corporation upheld, and there are times when it is otherwise. So it's a 50-50 for both parties.
Okay. Right. But we get clear instructions as to what, so it might be some documentation that might be missing, and
Right.
just to provide
Yes.
no additional costs, I
No.
would presume. Is there a stipulated time frame within which it should be resubmitted, or just to meet the next?
Well, if it's a situation where it is refused, the client has 30 days to indicate to us that they're making an appeal. And then that appeal is organized by that ministry that deals with the appeals.
Okay. I believe that's pretty clear. But what if I never knew all of this and I started building and without their permit?
All right. Well, we have had several cases, persons indicating that they were ignorant to the fact that a permit is needed. In some persons' view, they thought it was only in the towns. The rural areas were not subjected to said laws. However, just to inform the public, it is all the parish within every development within the parish boundaries are subjected to the laws of the land. So there's no exemption. Now, if there's a situation whereby you have started a construction and an officer or even the municipal officer, go to the site requesting your building permit or approval documents, and unfortunately you can't produce it, you will be served with the necessary notices. Now, there are a series of notices that can be served where we try our utmost best. Instead of have to go through all, we explain to the person as best as possible what are the breaches, the nature of the breach, what are the remedies, and we give them a time frame in which they need to do these remedies. Now, there is the stop notice and enforcement notice in both the Town and Country Planning Act and also the Building Act. Depending on the breach, the requisite notice will be served. However, currently in the parish, we have touched a little soft hand approach, I would say, where we offer these persons a warning notice, which has a 10-day time frame on it. We allow these persons to do their inquiry during that time instead of serving with the stop notice, because as they serve the stop notice, all the court proceedings and all the necessary processes start at that point. So when they serve their warning notice, I can basically say they are very receptive. They want the information, they want to comply. We rarely have to go through a stop notice and enforcement notice. We have offered a number of persons extension of the various notices because we want to be facilitative as best as possible, and we try our utmost best to ensure that at the end of it, we are satisfying the customer. So we offer those extensions, give them the necessary documentation, and they usually comply. However, we have had in the past a few that for whatever reason, they did not take the warning notice as forceful as they ought to. So we had to serve the stop notice with the allotted time. They still don't comply. We have to serve the enforcement notice. Unfortunately, they still don't comply. So as a result of that, we usually prepare necessary documentation, prepare summons, and take them to court. When they go to court, it can go a number of ways. And there's a number of penalties based on the offense under the laws, both the Town and Country Planning Act and the Billing Act, that they can be charged once the judge makes the decision. As per the Town and Country Planning Act, they can be charged up to $1 million or even up to 12 months hard labor as jail time. Under the Billing Act, depending on the offense, they can be charged up to $2.5 million. So I always say to my clients, even when they just come in with a warning notice, that 2.5 or that 1 million can add the additional money you may need. Don't let us go to court. Let us try and do the necessary remedies. Take in your plan, let us process and give you back a decision as early as possible.
Sounds fair enough.
Yes, right, madam.
Yes. So we have a couple of questions in the chat. Ramona Lawson, always bringing the questions. Ramona, we're going to take your questions in a little while because Ramona seemed to always to be preempting me. We're going to go right into the development part in a little bit. But before we get there, what is meant by a restriction covenant?
Oh, restrictive covenant. As it rightfully says, it has restrictions. And these are clauses that we find on the title, registered title, that limits the owner on what they can and cannot do on the property within their boundaries. It is usually as a result of a subdivision application forming from the conditions that these are placed as restrictive covenants. And when the application is transferred, the title goes to the transfer process and so forth. The title's office adhere to these conditions. Now, it can also come from the sales agreement between the two parties, the vendor and the purchasers, where the vendor may add some conditions that they may want to put on it. The restrictive covenants, in essence, runs with the land. So even if it is transferred from one party to the next, one family member to the next, it runs with it. Everybody has the same limitation, and it is hoped that the owner himself or even the person that the property has been transferred to will honor these restrictive covenants. So let me give you some examples of restrictive covenants. Restrictive covenants may be the type of sewage system that you can put on the land if it is an on-site system. It may also indicate to you that the land should be used only for residential or commercial, etc. It can also restrict you in terms of how you place the building on the land, in terms of your setbacks. So it's going to give you your setback from the center line of the road to the front the most outer part of the building, or it can give you the setbacks for the sides and the back. It limits you somewhat. There are even some conditions that I've seen where the developer actually indicates to you that you cannot do anything to the front section of the building. So these are just restrictive covenants that indicate to you to maintain the character of the area that these restrictive covenants are placed on it. And from time to time, yes, there might be a situation where they are breached, and these persons have to go through the court system, because it's the court system only that can actually modify or discharge a restrictive covenant. So they have to get an attorney, they file the necessary documentations in court, and the judge asks for the recommendation both from the parish council, the municipal corporation, and the NEFA. These are either discharged or modified as the case may arise, and unfortunately, it can be a lengthy process too.
Awesome. All right. So to lead into Ramona's questions, let's put some things in context. What is considered a development?
Let us just put it in simple terms first. Development is anything that causes a change. So if the property is just virgin land and you disturb the soil, that is considered a form of development. You're actually doing something to do something. But under the Town and Country Planning Act, development has a very detailed definition. Sometimes I remember it, sometimes I don't. I'm very honest with you, because it's that detailed. But in essence, development means carrying out of building, engineering, mining, or other operations in, on, over, under land, or making some form of material change to the use of any building or the land. You see what I'm talking about? It's detailed.
Very.
So
I'm hearing highway, I'm hearing
everything. As you can think it, it is development. Any changes that you're going to do on the land is considered a development. So most persons might be saying, but underland, overland, it's a lot. It's a lot to break down. It entails a lot. And that's why I said it is very detailed.
Indeed. All right. So let's go to Ramona's questions. Development applications are a good indicator of development in a parish. Over the last year, for example, how has the number of submissions increased, and in what development category?
I'll tell you, you would have thought that the unfortunate situation of COVID would have slowed the development in the parish. At no point at all over the past 2 years, we have had a break. We have always said, there are certain months that because persons may not be doing development as often, or even persons coming from overseas hoping to do their development before they leave again. But it has been non-stop. I can safely say over the past 2 years, we have been seeing increases, and it's in the land use type of residential. More houses are being constructed. We say for over a 3-year period, we could be moving from about 420 applications per year, and last year we had 472 thereabout. So it has been steadily increasing and continue being consistent. Residential developments, whether it's an erection or even a small addition, we have seen the influx, and we're very grateful that development is happening in the parish.
Indeed. All right. Next question. The turnaround time on building approvals is considered important in the development process. How well is the Clarendon Municipal Corporation doing here? And does the municipal corporation have a service agreement with clients in this regard?
All right. Let me take the first part.
Turnaround time.
So the turnaround time, the minimum processing time for a single family dwelling is usually in the minimum time frame of about 90 days. It is set in law, and I do believe that we have been meeting that time frame wholeheartedly. There are, however, a few percentage, maybe about maybe a 1% or 1.5% that goes over that 90 days, and it is with regret that because it's either due to discrepancies on the part of the client, not adhering to the certain standards or even in terms of documentation that are 90 days go over. For some application that we have to send externally outside of the parish, those may also have to go over the 90 days, as most of them do require environmental permit, which as itself alone takes 90 days. So to process the other aspect of the application, your planning permission and along with your building permission, then it goes over the 90 days. But I do believe maybe a 1% or so, 1.5% have gone over the 90 days. We do have that relationship with our clients where once it is that we're seeing they have been out of the loop for some time, we make our calls, we make our checks. We do send them the information as per their discrepancies. They do respond. Sometimes they have a little issue with the person who has drawn the plan. But we have, I would say, a very good relationship with our clients. Now, in terms of service agreement, it is not given to them solely in black and white, I would say. We will have those telephone conversations with those persons. We agree to disagree how it will be approached, how the various encumbrances will be taken care of. And I do believe we have been doing well in terms of that. Where customers may be aggrieved, our CEO has intervened. And of course, we try and do it as amicably and quickly as possible.
All right. Service agreement with the clients. Did you take that one in terms of a service agreement? Yes.
Yeah, yes, we did. Yes, we did. Yes, we did.
All right. Awesome. The other one, you would have responded to some aspect of it. How long on average should an applicant expect to wait before the development application process is complete?
Yes.
What are some of the common factors affecting processing time? You would have shared some of those. Any additional info?
Not that I can think of offhand right now, but those are the most common.
All right. So Ramon, I trust that all your questions have been answered. Winston, welcome. Does the municipal corporation have an approved list of block makers within the parish?
All right. We do not have an approved listing, but you can get that listing from the Bureau of Standards.
All right, Winston. All right. So the final question for this segment is, can residents object to a building permit or subdivision approval?
All right.
And
Well,
yes, on what grounds and what is the process for doing so?
All right. Now let us tackle the building permit first.
Yes.
Upon submitting your application, you are given a document called Notice of Intention. And it's a document that is in law also that we must present to our clients, and the client must erect same with immediate effect after receiving that from the municipal corporation. Now, the purpose of that document is to be erected on site so your neighbors can know that you will be engaging in construction. For whatever reason they may have, they can object to that within a 14 days period. If they do make the objection, we halt the processing of the application. We review their concerns. If it has merit, obviously we will have dialogue with the client just to sort out what needs to be sorted out. If it's a civil matter, we indicate to the person also to have both parties try and resolve it. Then we continue. If it's a situation where it may not have that merit, we just indicate to the person, explain what their grievance are, trying to remedy them in their own right. And usually the application continues. Likewise, for subdivision, it would be much the same, but we usually see that when there's some amount of dispute with the owners, maybe for whatever reason, the other is not satisfied that the other is taking care of their rights. We do have a dialogue with the parties as best as possible, try to be the mediator in those kind of situations. And most, I would say, they are resolved at the end of our discussion.
Fantastic. All right. And on this note, we're going to take a very minuscule break as we share some very important information from the Longville Park CDC in line with the Clarendon Municipal Corporation on the whole matter of property tax. So please take note. All right, I trust that you were able to see that, but in the interest of those who might not have seen, let me just take a brief moment to share what exactly was there. So, Longville Park CDC, that's a Community Development Committee, is reminding the citizens your property tax payment makes a difference. And they're making it easy for the citizens to take care of these payments. Both current and past due property taxes will be collected at the Longville Park Community Center, Sector V, Phase 2 on Saturday, this coming Saturday, June 25th, 2022, between 8 a.m. and 3 p.m. And they're reminding you that what your property tax does is to provide you with better community, improvement in infrastructure, improved services. And it also means that the NSWMA, through the Solid Waste Management Authority, are able to carry out the different work that they need to do. Clarendon Municipal Corporation will be able to provide you with those street lights and beautification, garbage collection, and the whole works, except the garbage collection is now under the NSWMA, right? Jamaica Fire Brigade. All of those are a part of the parcel why we need to take care of those property tax. All right. All right, let's take Romeo's question before we go to the next segment. Can the municipal corporation demolish a building if the owner is not in compliance?
Wow, very good question, Mr. Mitchell.
Yes.
Well, for the Clarendon Municipal Corporation, we have not had to go that route before. There are other instances under the Kingston and St. Andrew where that judgment to demolish has been cast. I do believe it is a medium after you have tried everything else and you have exhausted everything else that you had to reach to that point. And especially, when you think about having a building demolished, it must be hazardous. It must be some detriment to the public that you may want to go that extensive and exhaust every road. But we have not had to do that. Our clients, I believe, are very compliant. Our engineering team does so that the buildings are up to all the standards. So we usually not have to go that road. Our clients are usually quite compliant.
Awesome. All right. Thank you for that, Romeo. Great question indeed. And now we are going to move into looking at display of advertisement, because this is a very gray area, not so black and white sometimes, especially because I do a lot of work with startup businesses who are starting up, and more often than not, signage is not included in the overall startup cost for the business, because that's not one of the areas that they readily consider when you're going to start a store or you're going to take part in anything that involves a sign. So share with us the different categories of advertisement and the application process for each.
Okay. Yes. We share that same sentiment, that it is with regret that these proprietors do not consider advertisement as one of the most important aspect of their business. In fact, I've had a number of clients indicate in the past that when they do go to register, the company's office, that's not one of the things to tick off that they have to do. So it's actually when our municipal police may go out see the new advertisement up or so, or by the way they get the information. Otherwise, it is one of those applications that we are trying our utmost best to get the information to the public about its importance and the need to apply, because it's not just only a revenue source for us, it adds to the whole character of the towns. It's either the area has too many advertisements, the color coordination sometimes throw off another. So, and the placement is important, because some of them not only are on the frontal of their building, but it also they're also placed along the roadways, which if not placed properly, they can become a hazard to the pedestrian public. So it is an important application that we are trying to get all the processes tied down, the information out there. So I'm very appreciative to this medium too. So at least persons can tell a friend, can tell a friend. It is an application that you must get permission before you erect a sign. Again, you must get the permission before you erect the sign. There are conditions that are provided at the end of the approval process that you need to adhere to. Now, in terms of the different types of application, we have two that we currently provide permission for at the corporation: temporary and permanent. Temporary currently is dealt with by two departments, the planning department and the license and compliance department. For the license and compliance department, they deal with the place of amusement. So any event that has to advertise, the small parties, the dance, the drink up, etc. Once they made their application also for the place of amusement, they also have to apply for the advertisement at that department. So they would come to the office, request to visit that department, and the officer would process those applications along with their place of amusement. Temporary also, if it is a business, they may not be erecting a permanent sign at this time, so we also process those. Likewise, for permanent signs, it's twofolded. If it's going to be on their buildings, they come in, complete an application form, they make payment. Sometimes we ask them to draw the sign or taking a picture for same also. For those that are going to be on the frontal and not along a main road, it's just the application form and the drawings, and they make payment. It goes through a process of review. If it's a new sign or even a renewal, it goes to reviewing. And once it is satisfactory, it goes to a planning meeting, which is held the first Thursday of each month. We provide conditions, provide them with a letter, and they collect same and adhere to the conditions. For permanent signs, you only pay once per year. It's an annual payment for your sign. It goes through the similar steps as per the temporary. Fill out the application, pay the fee, goes to review, etc. However, if it is along our main roads, we partner with the National Works agencies to provide recommendations subsequent to that the approval is granted. So conditions may come from NAA, citing maybe the placement, the distance from the roadway, how many signs in the area, etc. And we place these in conditions once the application is approved. You have to pay the National Works Agency a separate fee from the corporation, so be prepared for that. Other than that, it's usually one fee that you pay on a yearly basis. You are reminded maybe a month or month and a half too before your approval is expired, because it's 1 year. There's an expiration date when you need to come in. So you're reminded. You get a reminder letter on a yearly basis. As best as possible, we work with the municipal police that are doing a tremendous job at this time. We are currently doing an audit for the entire parish, and I do believe, given maybe another 2 months, we will be able to complete that audit. Come next year, all things are on par. We will continue with the process, approving, informing as best as possible.
Indeed. All right. The documentation made mention of erection of a sign. What about those signs that are written on the building?
All right. Those are what we call painted on signs.
Painted, right?
Um, before I say, with regards to permanent or temporary, the size of the sign is important because that's how we calculate our fees. So you need to come in with the size as best as possible. Either you use a tape measure estimated, because when we go out and do our review, we do try and ensure that it is estimated properly. So for those painted on signs, those have to go through an approval process. Also, if it's permanent, it goes through the normal processes. The only difference is in terms of from the calculation of the size, it is not the background painted on area. It's actually the lettering that is calculated. So you take your measurement from the first letter to the last letter, and then you take from the uppermost point to the lowermost point, and that's how we calculate the size and indicate to the client how much they're paying per year.
Okay. It's pretty much like digital ads because it's the size of the banner that kind of
Yes,
the
precisely.
digital space.
Yes,
Okay.
precisely. Yes.
All right. There are a number of other questions here related to development. I mean, the hot topic development. John Sampson is saying awesome work. Clarendon Municipal Corporation. Nickala, Director of Planning. All right. All right. All right. Its team must be doing some really great work each month.
She's all the way from Antigua.
Ah, welcome.
Yes. Yes.
Warm
Yes.
welcome. All right, amazing. All right, before we take the other questions, because with all of that, you did say that you're going through a process now in terms of the entire parish and you're going to be doing your communication and all of that. But in terms of enforcement, especially for the temporary signs that are erected, tell us about that for the party billboards and all of that because they're erected on different locations along the stretch. Once the party, what system is in place to ensure that once those parties the days have passed that they're removed?
All right. So the license and compliance department deals solely with that aspect of things. But I'm aware that what happens is when the application comes in, a list is provided to the municipal police. They go out to do their audit, make their checks if they're up for extended period of time, they are removed, and so forth. So there's a process that is being adhered to.
Okay, so is there a cost if
If
it's
there's a
by
cost,
the municipal police?
you mean if for removal?
Right.
For removal,
For
not that I'm aware of at this time.
All right. All right. We'll have that conversation with that department. I believe they're coming up next. So we'll get into some of the other details there. But why is there a need for enforcement in terms of encroachment? If the size are not in alignment with specifications and the placement, why is there?
It's
I
it's a
believe you would have answered a
matter
part of it, but
It's a
go
matter
ahead.
for safety.
Yeah.
Safety for the public because as I said, they may be placed along the roadway that we have pedestrian traffic, the babies, the mothers, the old persons that hypothetically a sign hit them on the forehead. Who is it that they're going to come to? So we have to monitor these situations as best as possible. The municipal police are on the road. They're doing a fabulous job currently with all of that. And I do believe that persons are aware when they do make the application where the placement are and should not be. So I currently we're not seeing a lot of that, maybe one or two, but it's not prevalent.
Okay. All right. Let's take this one in relation to sign. Oh, John is saying thank you. All right. All right. The chat is moving fast now. Do you have signs that don't need to be paid for?
The sign, oh yes, there is under the Town and Country Control of Advertisement, there's a listing that I would say it's not a waiver, they're exempted. There's about 5 different types of sign that are exempted. One of which, advertisement on, say, vehicles. That's one of the exemptions. Advertisement inside the building is also an exemption, and a number of other exemptions are there.
All right. Let's take Ramona. There's a particularly useful and sightly sign at the entrance of Brands Crescent advertising a number of adjacent businesses. Are there plans to erect similar signs throughout the township?
All right, that was indeed a beautiful put together activity that was undertaken by the corporation. At the time, we got the buy-in from those persons along the roadway. However, based on the amount that we are able to charge them for the signs, in terms of mimicking it in other areas, it proved to be quite costly. I don't believe we have plans to do it in the near future. But if the businesses along a particular roadway come up with a petition, I'm sure it's something that we can consider.
Okay. All right. Because there are some locations that it would be quite useful, especially
Yes.
the bargain village and
Yes.
those locations where you have multiple.
Unfairly.
Right. Yes. Can an individual or group make a bus shed or welcome sign without the municipal corporation's approval?
It is not advised to do same as two things. A sign needs to be placed properly, and there are conditions of which that a welcome sign would need to go through in terms of review, in terms of placement. So we do not advise it. As per a bus shed, those are usually along a high traffic area, mainly main roads, and that has to go through a processing with collaboration with National Works Agency. So we don't wish for our good customers to do these type of activities before consulting with us and getting the requisite permission.
Indeed. Awesome. All right. Let's go back to Ramona's previous question. From your vantage point as the parish chief planner, what types of development do you think are most required in the parish to satisfy the needs and requirements of residents?
Well, I do believe it. Not in the short term, we have done any studies in recent years. But whilst we were doing our local sustainable development plan, when we went into the various communities at the local level and the local areas, they have cited a number of needs that they see. It was tabulated, it was compiled. From time to time, what we're trying to do is to execute some programs from those local area plans in order to satisfy the close-knit communities on its own. Thinking off the top of my head, obviously, there needs to be some form of sporting facility that the youngsters can utilize, etc. We need, persons may be saying we need that aerotropolis that some persons have been buzzing in the atmosphere these days. The highway is basically opening up the area for us. I know that there have been plans to take in a recycling plant in the parish, because we have to think about how we dispose our waste, plastic.
That's right.
It's not the most friendly in our oceans. So a recycling plant would do well. Even an transfer station for the solid waste. Otherwise, I think it would be one of our greatest need. But the highway is opening up a number of activities in and around the parish, and we do hope that the investors come on board, made their proposals. We go through them thoroughly, ensure that they meet all the standards, and of course, for the benefit of everybody in the parish.
Indeed. Awesome. All right. Romeo is asking, please explain what is a waiver and how an individual can get a waiver.
Well, it depends. A waiver for what?
Romeo, you're going to send a direct
You could
direct
say a waiver for
request
what?
to the municipal corporation on that one. All right. All right. This is an interesting one. Are there buildings that can be built that need no approval from the municipal corporation?
No, absolutely not. Absolutely not. Because once you're arguing, you're going to be disturbing the soil for any building at all. Yes, you do. Even containers, let me be very frank with you, even containers are considered a building under the Building Act. You know, if you're thinking of a tent or such delights, it will not require, it's not considered needing a building permit. But once you have to be breaking ground for a particular structure, it does render as a permit.
Okay. How are advertisement of vehicles?
It's exempted from under the law.
Okay.
Yes.
All right. All right. And this is a good note on which to wrap this episode for this month. All right. Stacey and Mesa is proud of you, boss lady.
Well, thank you.
Awesome. And Ramona thanks you as
Thank you, Ms.
well.
Lawson.
Awesome. Really rich sharing. Lady Thompson, thank you so much for making the time to share with us here on the Serenity Resource Connector. And we do look forward, just to remind you that we do this partnership with the Municipal Corporation on fourth Thursdays of each month. Next Thursday will be a fifth Thursday. So we are going to be having conversations with some vibrant youth in the parish of Clarendon. We're going to be having our second episode of our Clarendon Youth in Action. And you want to stay tuned to see what we're going to be talking about. First Thursdays, it's the Culture Corner partnership with the JCDC. Second Thursdays, we have our second episode in July with that partnership with the Clarendon Police, the Clarendon Division of the JCF. We're going to be talking more about community safety and security. Third Thursdays, we have that partnership with the Early Childhood Commission as we continue to look at the year of early childhood development. So we have each week we have a rich resource of experts coming in to share on their different areas so that we can learn, understand how it is to go about doing the different things in our parish so that we can live more meaningful and wholesome lives as we engage with these different entities. Thank you again, Lady Thompson, for representing the CMC so well. All right, and thanks so much to those who were able to join us live. For those who are watching the replay, thank you so much for tuning in. Yes, Miss Chase, well done, Miss Thompson. You're getting all right. Miss Thompson's gonna to go back and look at those live chat. You're able to see the live chat on Facebook, so you can check them out later. All right. God bless you all. Continue to stay safe. And don't forget to subscribe, set that notification bell, and share with your community. Blessings and plenty love.